Thank you, Mr. President. Just a couple of questions for the proponent of the bill, if I could. We talked a lot about what the intent of this legislation is and the policy behind it, but I just want to touch on a couple of questions about how it might work in practice. I was reading through the bill, and I understand that someone who is a member of this policy but not the policyholder themselves is going to be given this ability to make a determination about where the explanation of benefits is sent. But it's not really clear to me, reading the language, exactly when that change happens. Through you, Mr. President, can you let me know where that actually occurs? Does it occur at the time that the patient is seeing the doctor, or does it happen subsequent to that? And how is it conceived to be processed? Through you, Mr. President.
Thank you, Senator. Senator Lesser, would you care to respond?
Through you, Mr. President, I would refer the senator to line 109, which specifies that the insurer shall comply within 3 business days. So from the moment that the written request is received, there is a ticking timeline of 3 days by which for the suppression to go into effect. It would not be from the moment that the request was received, but it would be 3 days, 3 business days subsequent to that. Through you, Mr. Speaker. Mr. President.
Thanks, Senator Lesser. Senator Sampson.
Thank you very much, Mr. President, and I thank the gentleman for his answer. So if the person has to contact the insurer and make a request to redirect or withhold the explanation of benefits from being sent, I'm curious to know, does that policy stay in effect for any future claims, or would the member or patient have to make such a request each time a claim is filed? Through you, Mr. President.
Thank you, Senator Sampson. Senator Lesser.
Thank you. Through you, Mr. President, that would stay in effect for the duration of the policy unless the member writes a request to revoke that previously existing change. Through you, Mr. President.
Thank you, Senator Lesser. Senator Sampson, you have the floor.
Thank you, Mr. President. So the policy of not sending or redirecting where the EOB would be sent will remain in effect from the time that the patient requests it. That first brings up a few other questions. Does that mean that if a patient asks for the EOB to be withheld or sent somewhere else, is the person at the insurance company, they're supposed to review each of these requests to determine whether or not the member has the ability to make that determination on their own, based on the conversation we've had about whether or not someone might be a minor and they have the ability to make certain medical decisions in their own case, rather than being required to have parental consent. Through you, Mr. Speaker, or Mr. President.
Thank you, Senator. Senator Lesser.
Thank you, Mr. President. Through you, I don't know if the gentleman heard some of the discussion earlier, but I think the application of this bill to minors is very much intended to be the exception rather than the rule. So that in those very rare cases, those exceedingly rare cases where a child who is a dependent walks into a provider with an insurance card and is then consenting to one of the very specific statutory exemptions that exist under the law. In those specific cases, you're right, the insurance company would have to determine whether or not this is something that they would apply or not, and that would probably be tricky to administer. But the vast majority of cases, because would apply to adults who are able to consent to all medical treatment that I'm aware of, and that would be covered for the duration of the policy, or until such time as they notify in writing the insurer that they wish to to waive the suppression of the EOB. Through you, Mr. President.
Thanks, Senator Lesser. Senator Sampson, you have the floor.
Thank you, Mr. President, and I thank the chairman of the Insurance Committee for his answer. So I heard you say tricky to administer, which I think might be an understatement in this case, because I can only imagine a situation where a minor makes this request for something that they do have the authority to make the determination on, and then subsequently they file another claim where they do not. It will be incumbent upon the insurer, I'm guessing, although it's not laid out in this bill, to make that determination once again. I think that is a tremendous burden to be placing on an insurance company. You've mentioned the testimony that's before the committee a number of times, but you didn't mention the testimony from the insurance industry, which basically said that we would be the only state to make a policy such as this, that there is a similar policy in place that does allow the policy holder, who is the owner of the policy, to make a determination about where to send an EOB. But even that requires special circumstances. So here in this bill, we are actually setting up several different hurdles for an insurance carrier to accommodate our small state in how they're going to process these type of determinations. And I guess my further question is, what happens when they screw up? What happens when the insurance company does not send the EOB to the redirected address and they accidentally send it to the parent and ultimately the parent finds out about a medical procedure that they were not aware of? What happens in that point? Is there a penalty in this bill? Is there any liability created for the insurer in that case? Through you, Mr. President.
Thank you, Senator Sampson. Senator Lesser, will you respond?
Yes, thank you, Mr. President. I do want to respond to that question, but before I do that, I do want to correct several misstatements that Senator Sampson, I believe, may have inadvertently made. First of all, we are not the first state to pass such a law. Massachusetts passed a similar law, and this bill that's before us is closely modeled off of the existing law that protects people in Massachusetts. Second, I think the policy to which the senator was referring regarding allowing a policy holder to change the destination to which an EOB is sent completely misses the point of this proposal, which is, if we're really talking about protecting the rights of women, of people who are dependents, of allowing people to get life-saving domestic violence treatment because they are afraid that the policyholder, who was also the perpetrator of the abuse, might then retaliate against them for receiving medical care. If that is the genesis of this bill, saying that we don't need this bill because the policyholder, the person perpetrating the abuse, could send it to another address, misses why we're even here on this evening. So I hope that isn't missed by many members of this Senate, that there's a reason for this bill. The idea is to protect medical privacy of people who are on someone else's policy. That's what we're here to do. We are here in response to specific concerns raised by people on the front lines providing life-saving care to survivors of domestic violence, saying that you don't have to go to the person perpetrating that violence for permission or to inform them that you're going to try to save your life. That's what we're here to do. We're not saying to women wives and daughters that they have to tell before they can get life-saving care after a rape, that they have to tell the person who has, in many cases, perpetrated that they are going to get that care. That's why we're here. Now, who enforces this law? That's the Commissioner of Insurance. These are regulated insurance companies, and they have participated. They have worked in good faith with the chairs of the Insurance Committee and the members of the committee, and the amendment that we just voted on reflected the requests that they asked. That, I did mention it was tricky to implement, but we have worked with the insurance companies. We have taken their concerns into account, and those concerns are reflected in LCO 7188 that we just voted on. And now we're talking about the underlying bill that satisfies those concerns. Through you, Mr. President.
Thank you, Senator Lesser. Senator Sampson, you have the floor.
Thank you, Mr. President. I appreciate the response, although I would disagree that I mischaracterized anything. This bill is not exactly the same as the one that exists in Massachusetts. And most notably, in the state of Massachusetts, the exceptions that are allowed to minors are radically different than the ones in Connecticut. In particular, Massachusetts requires parental consent for a minor to have an abortion. That is something that is not the case in this bill. This brings me back to the start of this conversation, which is, whose policy is this? I don't know of another case where someone who is not the owner of the policy has the right to make determinations and changes to it, but is ultimately responsible for everything that happens with it. This particular bill essentially would allow someone who is not the policyholder themselves to get medical treatment and be billed for it, but yet when the policyholder themselves, who may have been left out of the loop, discovers that they owe a balance of a payment, or there is some other thing that might happen in an insurance claim, an adverse determination, any number of things could happen in an insurance claim, and yet the policyholder themselves is left in the dark. I'll go back to my statement, and maybe it's not the most politically correct one, but simply put, if you're concerned about your medical privacy, I think you should purchase your own insurance policy. What this bill does, unlike what was characterized as a restriction on people's rights, the amendment that sadly failed, which I think would have corrected every issue I have with this bill, that amendment didn't restrict anyone's rights whatsoever. It actually provided choice, which is something I know we're all very much in favor of. It gave the choice to the policyholder to make a determination on whether or not the other folks that are on their policy would have the right to medical privacy. If you don't like that as someone on someone else's policy, and you're the person paying the bill says otherwise, then I suggest you get your own policy. What this bill is about the rights of parents. That's what is eliminated if this law passes. Because if I am a parent who wants to choose a policy where I know what is happening with my child, I don't get to anymore, because you have taken my choice away from me entirely. The amendment would have given us the chance to do either or. It would have said, in some cases, parents might say, yes, my children have rights to their own medical privacy, but I think the vast majority of people, when asked if they believe that their minor child should have the right to seek medical care without their knowledge, even if it includes the billing and the processing of a claim and a potential adverse determination by an insurance company, I believe most people would say, yes, I need to know what is happening with my child. Now, I understand that there's some carve-outs in our laws that are valuable protections, but that's what this is about. It's a question about whether or not we are attempting to replace the parents' decision-making process with the government's decision-making process. It is also a not so thinly veiled attempt to take the rights of parents to know what's going on with their children away from them. And in particular, and I know it's a subject that has been amazingly avoided throughout this entire conversation, I believe this bill is before us for one express purpose, and that is to create a further impediment for parents to be aware of minor abortions. You can have any position you want on that policy, but it should be quite clear to everyone in this room that that's what this bill does. It is yet another impediment so that a parent would not be aware. We are one of only a handful of states that does not provide for consent or at least notification for a minor to have an abortion. And this bill only reinforces that by making it so a parent is going to be completely devoid, even if they are responsible for the payment of that abortion. I would also point out that the purpose of parental notification of abortion, which is something that is unbelievably mischaracterized by people on the left, is not to prohibit the choice of minor girls from getting an abortion. The point is to catch predators, which is what this bill is allegedly for us about. It is the mechanism to find out if the stepfather or the babysitter or the neighbor or some predator did something to some minor girl. If someone has the ability to do that, to rape and make someone pregnant, then they also have the ability to coerce that person to go and get an abortion. And in this case, I think they would have the ability to coerce that person to not, to make sure that the medical records don't show up in the parents also. Parental notification catches criminals and predators. It is a good policy. This is going in the absolute wrong direction, Mr. President. I think it is a mistake for us to take parents out of the loop when it comes to the medical interactions that their children have, and I'm going to be voting no on it. Thank you.
Thanks, Senator Sampson. Will you remark further on